Hello, everyone. Thank you so much for joining me for Wlbt Plus. My name is Kara Shirley, and I'm your digital news desk host. We are here today because Carly Gregg is going to be in court here in just a few minutes. Court was actually set to start at 1:30, and she is going to be going before the judge for what they are calling a settlement conference. Um, Now, from what my understanding of a settlement conference is when they are going before a trial were to happen, which her trial is set to start next week, uh, and possibly reach a settlement, a deal, a bargain, a plea deal, something along those lines. We're not sure that is what is happening. We just know that it's called a settlement conference that is happening today with Carly Gregg. You can see here up to the left side of your screen. We're looking in the courtroom right now, and we are waiting for the judge to come out and for Carla Gregg to make her appearance and for us to follow what happens today in the courtroom live as it happens. In case you are not familiar with the Carly Gregg case, Carly Gregg is the now 15-year-old, but at the time she was 14 years old, and she killed her mother and attempted to kill her stepfather. This happened back in March here in Jackson. Her mother's name was Ashley Smiley, and she was a teacher at Northwest Rankin, as well as Carly being a student there at Northwest Rankin. So, what we are doing right now is we are waiting again for uh, court to start, set to start at 1 o'clock, and that is what we are waiting on here. So we have a lot of you tuning in on our Facebook page as well as YouTube. Let me know what area of Mississippi or even the country, rather, that you are watching this from, tuning in from. But this is what we're waiting for right now. Again, Carly Gregg, 15 years old now. She was 14 at the time of the crime, and she is going before a judge today for a settlement conference. Carly allegedly killed her mother back in March. Her mother's name is Ashley Smiley, and attempted to kill her stepfather, and allegedly attempted to kill her stepfather. We are now waiting for this settlement conference to begin so that we can find out. Is there a deal being made from Carly and her attorneys? We don't know this. Will they still be going to trial next month? We're going to hopefully learn that today. We know that Carly, every 30 days, she's supposed to go before the court for a interest of justice hearing. Her attorneys did waive the last interest of justice hearing that she was supposed to have. And basically what the interest of justice hearings are is because Carly is being tried as an adult, because she is in an adult facility. They come before the court every 30 days just to get a look at and see of how Carly is doing being in that situation. Um, and so far, she is staying in the adult side of the prison, or the adult female side of the prison, and still going to be tried as an adult in this case. Today, though, again, we are waiting for that settlement conference to begin. We're looking live into the courtroom right now, and we are waiting for the judge to arrive. We're waiting for Carly to get there. Court was set to start at 1 o'clock. We're right at 1:04 right now. So, we're just waiting for it to get started. Looking here, we have Cynthia is tuning in from Carthage. Hello, Miss Cynthia. Danielle saying thanks for sharing the news. Well, thank you. Kathy Ford saying good afternoon. Danielle here is tuning in from Jackson. Randa is tuning in from North Carolina. Thank you so much, Randa. Freeman watching on YouTube from Forest. And then we have Anna Marie Shields here is tuning in from Pennsylvania. Wow, how about that? We have Oregon, Washington, Forest here with Mr. Caden Keaton tuning in from Forest. So again, if you are just now watching and you're wondering, what are we staring at? What are we waiting for? We are waiting for Carly Gregg to come into the courtroom. She has what is called a settlement conference today, and from what we've been told, what we can see is that settlement conference is when there's a meeting between parties involved in a lawsuit to reach an agreement before trial. Is that what's going to happen today? We are not sure. We are going to find out. We're going to find out live along with you guys. So you can see there, that is Carly's attorney right there. If you recognize him, or you may recognize him, he was also Beth Ann White's attorney. But that is Kevin Camp, and that is Carly Gregg's attorney there, or one of her attorneys. We are waiting for her to arrive in the courtroom, waiting for the judge to get in, and then we can get this underway, see what is happening today with this settlement conference for Carly Gregg. Again, Carly is she's now 15. She was 14 years old back in March when she allegedly killed her mother and attempted to kill her stepfather. Her mother's name was Ashley Smiley. She was a teacher at Northwest Rankin, as well as Carly being a student there at Northwest Rankin. Janessa Parker saying, not allegedly, she did, and may the punishment fit the crime. I understand you saying that, but in our justice system here, people are innocent until proven guilty. At least they are supposed to be. So until there has been a proof of guilt, in our eyes, it would still be allegedly. But I do understand what you're saying there. Melanie Mitchell is tuning in from Meridian, my stomping grounds. Thank you so much, Melanie, for tuning in. Cornelia Puckett's tuning in from Shivers, Mississippi. I'm saying that wrong. No, I'm saying that wrong. Jennifer Cooney. Coney says, wait until all facts are divulged before judging. That is correct. That is very correct. And then we have Miss Mary tuning in from Pearl. Thank you guys all for watching and tuning in. I do appreciate you jumping on here with us today during this 1 o'clock hour. The court was set to start at 1. Apparently is running a little late, which is to be expected. It is 1:07 now, waiting for Carly to come into the courtroom as well as the judge so that we can get this settlement conference underway, find out along with you guys what is happening here with Carly. As we wait for that, let me give you a little bit of news of some stuff that is happening here around Jackson, especially stuff that has happened over the weekend. So, of course, I'm sure everybody that is in or around Jackson is familiar with the fire that got started on Saturday at a tire recycling facility, and that fire is still currently burning. It's really kind of, once you get something like tires burning, it's really hard to put them out. So they're expecting that fire to burn until probably Wednesday or Thursday. If they are not able to get it put out before then, there have been firefighters there around the clock since the fire broke out, fighting it, trying to keep it contained at the very least. Also here in in downtown Jackson, there was a shooting over the weekend that left one person dead and 5 others injured. And it happened at the Daiquiri Bar on West Capitol Street. So the bar did release a statement on their Facebook page saying that they were deeply saddened by the recent incident that occurred at their restaurant. They're working closely with law enforcement to assist with their investigation, and our thoughts and prayers go out to everyone impacted. So Capitol Police are investigating the shooting that happened at the Daiquiri Bar. No names have been released, no arrests have been announced, but if you do have any information on this, please contact Capitol Police. So again, if you're looking at the screen up in the corner of this screen to the left side, we are waiting for Carly Gregg to come into court. Carly, the judge, there is a settlement hearing that is supposed to be happening today, a settlement conference that is supposed to be happening today. Supposed to get underway at 1 o'clock, and right now we're just waiting for everyone to come into the courtroom. Let me turn my volume on a little bit so I can see if we can hear what is being said. All right, seeing if they were saying the judge was fixing to come in or anything like that. As soon there is Carly coming into the courtroom. You can see her there. There's Carly right there. 15-year-old Carly Gregg. She is accused of killing her mother, shooting her mother in March here in Rankin County, and then also shooting her stepfather. She is accused of attempted murder for her stepfather, murder for her mother, and she is being tried as an adult. She is being held in the adult facility in the Rankin County Jail. There she is right there on the screen. As soon as the judge comes in, we will go full screen and go straight into there so you guys can find out along with us what is going to be happening today. Again, they're doing a settlement conference right now. The settlement conference where they can, it's like a preliminary step before going to a trial to possibly keep from going to the trial is a deal being made today between Carly and the state. We don't know. We're going to find that out today. So thank you for tuning in. We're going to go full screen for just a moment so you can check that out. And here we go.
All rise. Circuit Court of Rankin County is now in session. The Honorable Dewey Arthur presiding.
All right, please sit, please. All right. We're on the record, State of Mississippi versus Harley Madison Gregg, Rankin County cause number 2024-34169. All right, first matter we have is a competency hearing. State may call its witness.
Judge, before today's hearing, we spoke with the defense attorney and they have agreed to stipulate the competency. Dr. Gugliano is present in the courtroom. I told her she would be excused until that was done, and so we'd like to enter a copy of her report where she found that the defendant, Carly Gregg, is competent to proceed to trial into the record as exhibit to today's hearing.
Any objection?
Yes, sir. Yes and no, Your Honor. The exhibit as it is right now, we believe is improper. It can be a redacted version needs to be entered at this time, Your Honor, per the rules.
Well, Mr. Camp, you raised insanity. Therefore, I cited the rule in my order where you waive the redaction. However, this is what the court's going to do. There is pretrial publicity on this case, so I don't believe that I'm going to accept it as S1 over the defendant's objection. However, I'm going to see it. I don't. There is a right to publicity, but the court's going to weigh that pretrial publicity against the defendant's right to a fair trial, and I'm going to seal only this report at this time. The objection as to redactions, I did double check the transcript. I asked very clearly, or do you intend to seek an insanity defense? She said yes. So that's the reason why I allowed the state to have an unredacted copy first. Second of all, they had retained Dr. Gugliano, so I felt like they were entitled to it. Now, we get into a situation at trial. Portions of it may not necessarily be able to be used depending on the posture at trial. That's what we're going to do. Mark it for C1, mark it as S1, but I'm going to seal it at the end of this hearing. All right. Anything further from the state? As to competency.
Your Honor, the initial report, our motion in order asked that Dr. Gugliano prepare both an evaluation as to competency and to insanity McNaughton. The state has filed an amended motion asking that we be able to retain Dr. Jason Pickett and that Dr. Gugliano essentially be relieved of her duties to perform that McNaughton analysis.
But nothing further as far as competency, correct?
No, sir.
And the defense does stipulate the competency, correct?
That's correct, Your Honor.
Based on Dr. Gugliano's findings and the defense's stipulation, the court will find that this defendant is in fact competent to proceed, and we will move forward. All right, now, there was an amended motion by the state that you just referenced. I'm looking for that motion. Let's see here. Document 111, an amended motion for mental evaluation and McNaughton analysis. All right. So the state of Mississippi is asking that Dr. Gugliano be relieved from her obligation to perform a McNaughton analysis.
Yes, sir, Your Honor, that's correct.
You want to hire somebody else to perform a McNaughton analysis.
Yes, sir, Your Honor. Dr. Jason Pickett.
Okay, what type of doctor is Dr. Jason Pickett?
He is a forensic psychiatrist. Also, he has did his residency in emergency medicine as well.
Okay. Have you informed him of the trial?
Yes, sir, Your Honor.
All right. Anything further from the state?
No, sir, Your Honor.
Response by the defense.
First of all, Your Honor, when Dr. Gugliano went and did the, I guess, the competency hearing, she got halfway through her evaluation on McNaughton, and they were just supposed to continue. So we don't understand why they're having to switch to somebody else when that person evidently is qualified to do it and was doing the investigation.
Dr. Gugliano here.
She is, Your Honor.
Yes, Your Honor.
Of course, we'll call Dr. Gugliano.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Do you understand that you're now under oath and answer some of the questions?
Yes, I do.
This is one more thing. The court's going to ask a few questions, then I'll turn it over to the state, then I'll let the defense ask any questions. Any objection to that by the state?
None from state, Your Honor.
By the defense?
There you go.
Dr. Gugliano, why did you not perform a McNaughton analysis on the defendant?
I started interviewing Ms. Gregg regarding McNaughton analysis, but we had been meeting for about 5 hours at that point, and there was a person sitting in the room next to us who we could hear, so I'm assuming that they could also potentially overhear us speaking. And so we stopped at that point, and I was going to reschedule. In working on my competency report and reviewing records that I had received, I believe on 2 days prior to my interview of Ms. Gregg, it seems that medications are going to be relevant to her mental state at the time of the alleged offenses. As a psychologist, I do not have expertise in medications or the potential side effects or impact that medications could have on someone's mental functioning. Therefore, I let Ms. Newman know that I thought it would be better to have a forensic psychiatrist perform the evaluation because they would be able to fully answer the question.
All right. Turn the witness over to the state.
Dr. Gugliano, you were ordered to evaluate the patient. What records did you receive from the defense attorneys prior to interviewing Carly Gregg?
The defense attorneys provided me with Magnolia counseling records from individual therapy that she was receiving.
And there was no prescriptions anywhere in those records, is that correct?
Not in those records, no.
Did they provide any additional records showing the prescription medication that the defendant was on?
No, they did not.
And so we provided those when we received them on August the 8th. Was that the first time that you had records in front of you talking about the use of any antidepressants or medication?
Actually, let me rephrase that. The counseling records did refer to Ms. Gregg being prescribed medication from Precise Neuroscience Center, I believe, or clinic, but I had not received those records yet. And so I wasn't for sure how accurate the records were that the counselor noted. I'm assuming that she was told about the prescriptions from Miss Gregg, but I cannot say that for sure.
And as of this date, you still don't have any pharmacy records, is that right?
I do not.
And based off of what you told the judge, now that you know there were antidepressants that were prescribed, is it your testimony that you do not think that you'd be able to complete the insanity portion of the evaluation?
It's not just that she had antidepressant medication prescribed. It's based on the brief amount that we talked about what was going on with Miss Gregg around the time of the alleged offenses, like in the month leading up to them. Her medications were switched, and so there may be a question of withdrawal from medications and how those may have interacted. So it's the fact that side effects or withdrawal symptoms from the medication could be relevant to mental state. That is my opinion, why I'm not the best expert to do that type of evaluation.
And as you sit here today, you can't say, Dr. Guglielmo, whether or not there were any withdrawals or that could actually be an issue.
No, I cannot. That's outside of my scope of expertise.
No further questions, Brian?
Other things.
No question.
Is there somebody at Mississippi State Hospital that could have, whose area of expertise does that lie within?
It would be a forensic psychiatrist, in my opinion, because they have both the medical training and the forensic training to complete the evaluation.
I understand you no longer work at the state hospital.
I do still work at the state hospital, but I also do private work.
Is there somebody at the state hospital that does, that would be qualified to do that? Or would it?
Dr. McMichael, who's the service chief, is a forensic psychiatrist. However, he has some medical issues going on right now, and he would not be available at this time.
Anything further in line with the course?
Gary, just that Dr. Jason Pickett does in fact, does he also provide evaluations for the northern part of the state, sometimes through the state hospital?
Yes, he does. He's a Department of Mental Health certified forensic evaluator.
No further questions.
Anything further for the defense?
Mayor.
You stand. All right. Does the state have anything else in the way of requesting Dr. Pickett?
Other than this sort of hints on our other motion to compel, but we were told that we would receive a copy of a report from Dr. Mark Webb from the defense attorney back some time ago, including again last month, and we don't have that. And so we feel that we need Dr. Jason Pickett to go ahead and evaluate this analysis regarding any potential medication or insanity defense, even without receiving a copy of Dr. Webb's report.
Is that correct? Dr. Webb still has not turned over a report?
That's correct, Your Honor.
I thought I was told July 22nd his report would be complete, and then I did an order for a week after that. And here we sit a month later, and we don't have a report.
Correct, Your Honor. He's still evaluating her. In fact, I think he went, was it last week? Yeah, he was evaluating her and adding information and making sure that his report is correct. And as soon as we get it, we were hoping to have it by the end of this week.
Was Dr. Webb informed of the court's order? I entered an order, he was supposed to turn it over. As I recall, defense counsel offered up early July, and then early July came July 22nd. And then I gave an extra week after that. So why don't?
Your Honor, he's not finished with his evaluation. As soon as he gets done with his evaluation.
When do you anticipate the evaluation being finished?
I'm sorry, what?
When? When does he anticipate?
We are planning to have it turned in by the end of this week. That's what, and we've informed council offices that that's what we're shooting for right now. But I can't turn it over until we get it. I can't give you right now.
I'm not putting Dr. Webb driving this bus. This court entered, there was an order from the county court, there was an order from this court, there was a second order from this court. And that was based on dates that defense turned over. He was hired in April. All right, the motion in front of the court at this time is whether or not Dr. Jason Pickett can evaluate the defendant. Court's going to grant that order. However, there are parts of that order, for example, it says the defense is to turn over discovery. The state has its discovery, the defense has to turn over their discovery. Do you have your proposed order?
No, sir, Your Honor, and I'll tell you why. The motion that we use tracks the language when we have somebody from the state hospital evaluating the defendant. There was some discussion about whether or not we could get Dr. Giuliano's report and whether that would be redacted and who that would be sent to. So I wanted clarification from the court about whether Dr. Pickett would provide his report directly to the clerk pursuant to Rule 12, or whether that report would be provided to my office to be turned over to the defendant. And so I have not prepared an order yet.
All right. This is going to be the court's ruling. The court's going to allow the state to submit this to Dr. Jason Pickett. The state's turn over a copy of the order before the close of business today. Any and all related motions, exhibits, and materials must be turned over by the state to Dr. Pickett by the close of business tomorrow. I don't know why we need a completed patient information form. I don't believe that's necessarily required. Information related to the alleged crimes, discovery materials are to be turned over by both sides, both the state and the defense, before the close of business tomorrow. Copy of the defendant's prior local arrest record and NCIC or FBI identification report, any of that would be in the control of the state. The state's going to turn that over by tomorrow. Information concerning the defendant's mental health and medical history, including a copy of the report, file of any psychiatric, psychological expert, providing any previous forensic opinion or evaluation of the defendant. Both sides will turn that over by the close of business tomorrow. All relevant medical, psychiatric, psychological records, and all relevant educational and court, including youth court and employment records, will be turned over by both sides by the close of business tomorrow. Both sides could file a certificate of compliance by the close of business tomorrow. However, I'm forewarning the state, I'm trying this case this time. So Dr. Pickett better be ready to try the case. As to the medical report from Dr. Webb, this court has serious concerns. I cannot for the life of me understand how Dr. Giuliano is able to go interview and turn over a report within a couple of weeks, but Dr. Webb's not. I really, Dr. Webb is not going to be driving the bus. If you don't turn over the report by the close of business tomorrow, this court's going to look at exclusion.
Your Honor, just for the record, and the rules speak that we have till the 30th of August to turn that over. It's also, we have till the 30th of August to, actually it's 10 days after that. But it says that we have to, that's when we have to file our notice as far as insanity. That's what is the determining factor, is whether or not we are using the insanity defense. We have not done that yet. We are still within our time frame to do that. Once we file our notice of insanity, if we do that, Your Honor, then what happens is that sets some things in motion. Within 10 days after that, we have to provide any reports, any information that was relied on has to be provided to the state. That's what the rules say.
That's not what the rule says. The rule says in any event, not less than. However, the willful holding on to discovery material and not turning it over in order to obtain a tactical advantage falls under Taylor versus Illinois from the U.S. Supreme Court.
And Your Honor,
And
we don't
it
have
says
the order.
very clearly that exclusion is appropriate. in those circumstances. This court finds it very circumspect that Dr. Webb is not able to turn over a report. Has defense counsel turned over the records you intend to rely on in the trial?
Most of the records, Your Honor, have come from the state. And I think
So what's the holdup
we've
for Dr. Webb?
We've
You
turned,
gave everything over to Dr. Webb you intended to rely on. Why are we here 4 months later? You're telling me, well, Dr. Webb will get to it when he gets to it. The rule does not say you can hold your discovery until 10 days before. You have to read Rule 12 and Rule 17 together. Rule 12 requires a prompt disclosure. And I'm forewarning the defense, this is beginning to sound like a willful attempt to obtain a tactical advantage as outlined in Dilla Beckwith versus State and Taylor versus Illinois.
and Your Honor, all I can tell you is that he is still evaluating her as of as late as last week. And so when he,
Is Dr. Webb here today?
No.
Did you inform him of the hearing?
Yes, Your Honor, but he knew we were not objecting to her competency to stand trial. And that there would be a stipulation.
he's only testifying about the McDonald issue.
Well, look, you're gonna be able to preserve your argument for appeal, but the rule does not say you can hold off and wait to turn over the expert opinion until you want to. That's not what the rule says. The rule doesn't say you can wait for 10 days before. You noticed this court in July that you were gonna be obtaining a medical expert. It is total ambush, a complete bushwhacking to hold the report till 10 days before. And that is not the purpose of an insanity defense. Mental health, insanity defense is a shield for Ms. Gregg. But at the point she tries to turn it to a tactical advantage, she loses that shield. And the state of Mississippi can raise that with the jury. And if you're going to be trying this case in front of a bunch of people that went to vacation Bible school, this little light of mine, I'm going to let shine, hide it under a bushel. No. Why would we hide this under a bushel? Why would you wait till 10 days before trial? If she truly was insane or truly was under the influence of these drugs, why hold it till 10 days before trial? It looks bad from a jury.
Yeah, we're not withholding it intentionally 10 days before trial. First of all, the rules specifically speak when we have to file our insanity notice of insanity defense. We have not done that yet. The case law is very clear that putting the court on notice that we are getting an expert to look at insanity is not putting the court on notice that we are offering insanity defense. We have until the 30th of this month per the court's order, because that's when the motions have to be filed by the 30th of this month. On that day, we have to have done notice. We're getting it done earlier, and we're working on it. We don't have the report. Dr. Webb is being very thorough in what he's doing because this is a very important case. There's very complicated issues. And so as soon as we get it, we are going to provide it to the state. We are not hiding anything.
What have you turned over to the state?
We turned over everything anything that we have had that they don't, we have given them.
What's the state receive from the defense?
Absolutely nothing. Not one piece of paper, not one name, not a phone number. That's why we filed a motion to compel compliance with rules, criminal procedure 17, back in July, asking for discovery. We've sent multiple emails. We've asked multiple times. We've asked in person. We've been provided absolutely nothing.
Response?
Your Honor, we provided counseling records that we received that the state did not have. We provided those. I'm sorry, Your Honor.
What date did you provide those?
Your Honor, I can't recall off the top of my
What
head.
proof do you have that you provided them?
Well, I mean, I have emails.
Do you have those?
If I can find my phone. And I believe we also provided those same records to the state's experts, but everything else has been what we've received from the state.
That's not entirely correct, because in the report that Dr. Gugliano did have, I noticed there was a statement from the stepfather that it's the first time that's ever been testified to in court, unless you can show me somewhere in the discovery that it was. I've not seen the discovery, but I heard the man testify, I read the transcript, and I sat down with the report, and there's new information in there that's nowhere in the testimony that does contradict what was stated under oath. So how long did you know about this statement about her mental status in the days before?
Your Honor, I believe we've talked about that since April, on the record in county court.
This is where we are, both sides. The proponent of the evidence bears the burden of showing where you turned it over. Both of them. If you haven't turned it over by the close of business tomorrow, it's not coming. Order to compel is granted, both sides. Your discovery will be turned over by the close of business tomorrow, or it's not coming, period. If it's not in your custody, that's fine. That's one situation. The court will look at when it came into your custody, but the person offering that proof is going to bear the burden of proving when it came into your custody. Do I make myself clear for the state?
Yes, Your Honor.
For the defense,
Yes, Your Honor.
close of business tomorrow.
Your Honor, I'd like to make an exhibit to this testimony as well, where the state has requested repeatedly for discovery, as well as the emails between myself and Ms. Todd, where she absolutely did not provide those records to me, where I asked repeatedly that they be provided to me, and she said she turned them over to Dr. Gugliano, so it's disingenuous at this time to state that she actually sent those to me.
Objections for the record. Objections for the record by the defense.
Your Honor, I haven't had time to look through these.
Show them to her.
I emailed them to her earlier today. She responded to my email about a plea offer, so I feel certain that she received the email.
I received an email today that I responded to Catherine asking her if the state intended to
Okay.
offer.
But the state is offering emails. Show them to defense counsel.
I just gave her a copy, Your Honor.
Objection as to the introduction, as to the court moving into the place.
No objection as to the court
Will be
meeting.
marked as to. I have a very simple question. This court signed an order on July 3rd, 2024 for mental evaluation and analysis. The emails that I'm seeing are July 30th and July 31st, where the state is asking for medical records. What date did the defense turn the records over to Dr. Guglielmo?
Your Honor, if you'll look back, you'll see on Monday, July 22nd, I emailed the records to Dr. Giuliano with Catherine Newman CC'd on that email.
Dr. Guglielmo, did you receive medical records on July 22nd?
I believe so. I don't have the date with me, but that sounds about right.
I can show you the emails, Your Honor.
You want to make them exhibit?
This was Catherine's exhibit, she gave it to me.
Your Honor, if I may, she copied the email that she sent to Dr. Gugliano, then sent me an email that says FYI. There were no records attached, which is why I asked no less than 5 times on the 31st to please just send me the records.
Your Honor, may I approach?
Sure.
You'll see. Maybe this is actually where I sent the records and then where I forwarded the email.
This isn't a reference.
That's right. I'll look what Catherine gave you.
Well, if you want to make a separate exhibit, show it to her. If you want me to look at it, show it to her. And you can mark yours defense exhibit.
Yeah, I'm confused. Where does it say it was sent to me?
Do you have an objection to it coming in?
I have an objection based off what she's claiming it to be, so yes, there's an objection to that. It's in the packet, Judge. Nowhere is my email listed in the top of that email where she sent the records.
Objection overruled, mark it D1. All right, for the record, you've highlighted purple, correct?
Yes, Your Honor. And then the email's below where I forwarded the email with the document.
Ms. Todd, that's not what this shows. I mean, it's going to speak for itself. You sent these to forensicsiteservices.ms@gmail.com. You go down, Amanda Gugliano responds to you, received, thank you. Then you email FYI, thank you, but there's no attachments.
When you get forward, you see where it's attached.
I see where it was attached to Dr. Gugliano.
Right, yes, Your Honor. You can continue to go. You'll see where Catherine even asked about the dates on the records, and I tell her where the dates are on the records.
All right, I do see. Can you let me know where the records are from and what dates? The Blue Cross Blue Shield printout shows that she saw multiple counts. All right. I will say this for both sides. The purpose of discovery is to obtain a just and fair result. This court will not stand for an attorney playing discovery games. Close of business tomorrow, both sides. You either turn it over, and you can prove to me you turn it over, and I'm not talking about an email saying, see, there's some records attached. There will be something to the effect of, we've bait stamped documents 1 through 200, here they are. If they're not in the discovery tomorrow, they're not going to come in unless they are not in your possession. The purpose of discovery is to reach the truth. It is not to ambush either side. I'm going to be frank. If the young lady was suffering from a mental defect or illness or medication, then she should be set free. But if she's not, period. That is a perilous argument. The jury's going to make this decision. Holding discovery does not help anybody. It does not instill trust from the public that a truthful justice is reached. And this court's going to make sure both sides get a fair trial. Only way I know to be fair at this point, y'all turn over your discovery. Close of business tomorrow to both sides, or it's not coming in. It's just that simple. All right. Are there any more motions by the state?
No, sir, Your Honor. I believe that handled both our motion to compel the compliance with your rule about the mental evaluation order as well as the general motion to compel.
Motions by the defense that I've not handled, that are pending or noticed for today.
No, nothing's noticed for today, Your Honor.
Has the state of Mississippi made a plea recommendation in this case?
No, sir, Your Honor.
Do you intend on making a plea recommendation?
Possibly, Your Honor.
Well, it'd be a good day to do it.
Yes, sir, Your Honor. We received the report on Friday afternoon. There were brief discussions between our office and Mr. Camp, and that's as far as that has gone.
You've got till this Thursday to reach a plea agreement if you want to reach one. If the defendant wants a term of years, then we have till this Thursday to reach that. Otherwise, it's an open plea to some offense. Negotiations are going to wrap up this week. I caution both sides to be very careful not engaging in plea negotiations. I read the mental evaluation from Dr. Gugliano, and I understand the defendant may not be interested in plea negotiations. This only goes a couple of ways. If a jury finds that she's guilty and fixes the punishment, life is life. If they can't fix the punishment, I have to decide. It's a minimum of 20 to 40 years. If the jury finds her not guilty by reason of insanity, she goes to Whitfield for some indeterminate period of time. Could be a week, could be 10 years, don't know. But come this Thursday, Ms. Gregg needs to understand it's out of her control. The state needs to understand you're not coming to me after the deadline and saying, well, we'd like to plead her 25, 30 years. I'm not doing that. This Thursday, 5 o'clock, she's either going to enter a pretrial conference checklist or a guilty plea petition. I don't care which it is. Is that clear?
Yes, sir, Your Honor.
Is that clear to the defense?
It is, Your Honor.
All right. Do we have anything further? Last time on the state,
Nothing from the state, Your Honor.
on the defense.
Nothing, Your Honor.
All right, we'll be in recess.
And we are back. All right, sorry about that. So, Carly Gregg did go before the judge today, and what they discussed was several items of discovery that has not been, according to the state, those items of discovery have not been turned over to them. Let's see, I have several notes that I made during this. So they talked about a competency hearing, or hers going before meeting with some psychologists, psychiatrists, and things of that nature. She had originally had a evaluation done by Dr. Amanda Gugliano. She is a psychologist with Mississippi State Hospital. And what the state requested was that Dr. Gugliano be replaced by Dr. Jason Pickett. According to Dr. Gugliano, she did take the stand, and according to her, she believes that this is outside the scope of her expertise based on several different factors with Carly. So she was asking to be recused from this, and they replace her with Dr. Jason Pickett, and the judge did agree to this, as well as the defense. So that is what is happening with that. It's a lot of information come through, so apologize if I am staring at my notes. Want to make sure that I get it all out there to you guys. So the defense did request did have a doctor evaluate her, and that doctor, Dr. Webb, his medical report was supposed to have been turned in by July 22nd. There was a court order from the county court and 2 from Judge Dewey Arthur's courtroom saying that his report had to have been turned in by July 22nd. Well, that report still has not been turned in. According to Carly's defense, Kevin Camp, they have not received that report yet from Dr. Webb. Kevin Camp stated that Dr. Webb, as soon as last week, was still evaluating Carly, and his report had not been done, but they do anticipate having that report by the end of this week. Well, the judge did not seem happy about that because he brought up how they were supposed to have it turned in by July 22nd. It was not. Then it was supposed to be ready by today, and it is not. And they're still saying it's going to take more time. So what Judge Arthur has put in place is saying that both sides, both state and defense, must have all of their discovery turned in by close of business tomorrow. Everything turned in by close of business tomorrow. Stated that if it is not turned in by close of business tomorrow, then nothing is past that is going to be allowed into trial. So whatever they have to be allowed in trial must all be turned in by close of business tomorrow. If it is not, it will not make it into the trial unless there are some extenuating circumstances. And the judge said that he would look at those on a case-by-case basis. But for the most part, if it's not turned in by close of business tomorrow, it's not going to make it into the trial. The judge also stated that what happens when discovery is not turned in on time, or if it is, they wait until right up until the time of the trial. And he brought this up because Kevin Camp mentioned that they actually had until like 10 days before the start of the trial to turn this in. What he said was then it looks like a willful attempt to withhold information. He also stated that that discovery is intended to help protect the truth and to give both sides a fair trial. He says without everybody having all of their discovery, all of their information, all of their documents, everything turned in by a standard or a set time, then it looks like favoritism is being shown to one side or the other. So that's why he is saying it must be turned in by close of business tomorrow. And if it is not, it's not going to be making it into the trial. Both sides must also file a certificate of compliance, which means they have to show proof to the judge outside of it just being an email print off or anything like that. They have to show proof to the judge of what all they submitted and their submission date. So that is required by both sides, both the defense and the state. Again, if it's not turned in by close of business tomorrow, it is not going into the trial. He stated that several times. He also said, as far as the insanity defense, he asked if they were going to be holding or they're going to put forth an insanity defense on this. And what her attorney said, he actually said, if we do an insanity offense, if we do that. So he did not rule that out. Kevin Camp did not rule that out, but he did say, speaking on turning in discovery, he said, if we do an insanity defense. So we are still waiting to know whether or not that is going to happen, if she's going to be pleading guilty by reason of insanity or anything like that. Also, the judge went on to say the insanity defense in the state of Mississippi is meant to be a shield for someone who is has mental competency issues, and that if one side or the other tries to use that insanity defense as a tactical weapon, then what happens is it removes the shield. The person is no longer protected because the thing that was supposed to be protect them is being used as a weapon, and it doesn't work that way. So all of the discovery must be turned in by close of business tomorrow. One thing that a lot of you guys pointed out in the comments, and I noticed it as well, was that Carly, at one point when her attorney was looking over some paperwork, some documents, Carly had looked to someone in the crowd and winked at them. That happened. I looked at the time. It was 1:38 when that happened. And so a lot of you made that comment saying that she did that, and some didn't see it, but I caught it as well. I caught it before you guys even mentioned it. So yes, she did actually look at someone that would have been there in the audience and winked at them. So the judge also asked the state if there was any plea deal in the works at this time, and they said there is not one at this time, but it is possible for a plea deal to happen. Well, the judge said that they have until this Thursday to have a plea deal in place if that is going to happen. They have until this Thursday, which is the 22nd of August. So all discovery must be turned in by close of business tomorrow, which is Tuesday, the 20th of August. If it is not turned in by close of business tomorrow, then it will not make it into the trial. Anything that is not turned in, anything that does not have a certificate of compliance proving that it was turned in, will not be allowed into the trial unless there are extenuating circumstances. Also, they have until this Thursday, the 22nd of August, to decide if they are going to offer a plea deal, and for Carly's side to decide if they are going to accept a plea deal. So that is where we are at right now. Her trial is set to start next month. It looks as if, unless a plea deal is reached, that she will be going to trial. She will be charged as an adult for murder of her mother and attempted murder of her stepfather. Of course, all of these crimes are alleged at this moment because she is innocent until proven guilty in a court of law. But that is where we are at right now. So Carly will be having an evaluation done by Dr. Jason Pickett. And then the Dr. Webb that the defense had Carly meet with and do an evaluation must have his report turned in by close of business tomorrow, along with everything else from both sides. And that's what we're waiting on now. We're waiting to see, does all of the discovery make it in? Is it all turned in when it's supposed to? How it is supposed to? And will there be a plea deal? We will hear about that on Thursday. I am assuming that we will hear about it if it happens or if it doesn't. Either way, we will let you guys know what we find out. And I do definitely appreciate all of you for tuning in. I appreciate you and all of your comments here and joining in the conversation here with this. We do appreciate you guys. I will be back again tomorrow at 1 o'clock, so make sure you are tuned in then for WLBT Plus. And as promised, we are keeping up with all of the breaking news. Make sure also you tune into our newscast tonight. All of our newscasts tonight, because we are going to have some updates on the tires that are burning, the tire recycling plant here or not a plant, but tire recycling facility here in Jackson that is on fire right now. Hundreds and hundreds of tires burning, and firefighters are working hard to keep that fire contained. We're going to be giving you some updates on that and updates on other stuff that has happened. So make sure you tune in to our newscast. Download the WLBT app so you can get breaking news alerts as it comes in here to us, as well as the First Alert Weather Team, so that you can get those notifications on your forecast right where you are. Also, 2:30 today, our First Alert Weather Team will be in here talking weather, so make sure you are tuned back in for that. You guys have a great day. Thank you so much for tuning in. I'll be back tomorrow at 1. See y'all later. Bye, y'all.